Today's show is brought to you by the Westlaw Reference Attorneys. Long considered to be one of the best parts of Westlaw, these complimentary 24/7, 365 research assistants are available to help you start your research with the perfect search. Continue your research by finding the perfect source and a bunch of other exciting things. Try them today at 1-800-REF-ATTY or reference attorneys at tr.com. It's time for another exciting episode of Fundamentals of Westlaw. I'm your host, Samuel Bourbano. You're already an expert at getting ready for class and doing some basic cases research, but we'll broaden that out today with secondary sources, the West Key Number Digest, and the KeyCite Citator. You'll see my contact information down there if you've got questions. Otherwise, tweet them in to @LindyHopLawyer or follow along. As I said, you are experts at accessing Westlaw for basic case law research. That's getting ready for class. So let's take a look at a brief review. We'll make sure that you are going into lawschool.westlaw.com. And then from the big bar at the top, clicking on Westlaw to see this. Most of our work today is going to be through that big blue bar at the top, and you'll notice that white space says that you can enter in quite a few things. We'll be doing that right now. In addition, to the right of it, the jurisdiction, which stays sticky from the last time that you did some research. To the right of that, a search button and the advanced button as well. Now, we know that you can find cases based on the name, Garrett versus Daly, but there's a bit of a pitfall, a danger there, because when you do that, there are a couple options. In fact, with some of the most common names of cases, there may be more than just a couple options. So how do you tell these things apart? Well, you can tell them apart by their citation. So each of these is a citation, the top two corresponding to that first case, the bottom two corresponding to the second. And of course, you can tell them apart based on the date. One of them from 55 and the other from 56. But rather than go through that long process, if your case name is more common, you can always type in the citation, because there will only be one case with that citation, and it's, of course, Garrett from 56. Within the case itself, you can do a number of things to help you get ready for class. And the first is to use the West headnote and key number system. The headnotes, written by attorney editors based in Eagan, Minnesota, will help you get ready for class by understanding some of the factors and the conclusions of the case. Specifically, Garrett is, of course, about the idea of substantial certainty. And that seems a little bit strange, doesn't it? I mean, how can you be substantially certain? I feel like certain is you either are or you aren't. So that one word might be something that the professor spends a very long time discussing in class. How do we arm ourselves for some of those questions? Well, that's where you're an expert, because by using Black's Legal Dictionary, which we've gone ahead and typed from the big blue bar across the top, and you'll see how it pops up. Mouse it over for it to turn blue, and then give that a quick click, because we're going to use that to define the term certain, so that way we're ready for class. From Black's Law Dictionary, you can type in a dictionary term, or even just type it up here in the top. Don't worry about that word advanced, that happens naturally. And of course, by scrolling through some of the results, you'll see that the idea of certainty is parsed out pretty finely by the sources. And when we click into certainty, you will, of course, see a definition that will help you when the professor calls on you in class. I wanted to provide you a brief preview of what you'd expect to see today because this is an example of a secondary source. Secondary sources are written by people like Professor Centel in sources like a law review and written to help you understand their point of view, either about a legal controversy, an important case, a certain issue. In this case, this is 167 pages of Professor Centel's mixtape for torts. He's dropping the beats where he goes through poems and recites some of the major facts and conclusions of big cases that folks learn in law school, like Paul's graph. But without further ado, a little bit of a recap of the Westlaw basics, right? And so those are three things. We are going to find a case, right, based on the name or the site. And then from the case, we can read the case by reading the headnotes first, before you read the opinion, because the headnotes tell you a little bit about what you can expect to see within the opinion itself. And then the other thing we'll do is use Black's Law Dictionary to define ambiguous terms, and then from there build out our case preparation for class. Now that that brief recap is over, we're going to cover the West Research Pyramid, secondary sources, key numbers, KeyCite, and a few complementary resources. So the goal of this exercise is to give your professor, or in real life, the judge, controlling authority in the form of a perfect case. And why do we start with a case? If you think about your disagreements that you may have had as children, either with a sibling or with another friend, those disagreements sometimes talk about cases. Maybe after the doctor's appointment, your younger brother got ice cream and you didn't, right? When you are talking about a case, something that's happened before, and a conclusion that has been made, you are hoping that the fact finder will be consistent. But sometimes the outcome isn't the same because there are different distinguishing things. Maybe your younger brother's appointment went well, no cavities, and yours went poorly, lots and lots of cavities, and so that's why you didn't get ice cream. The process of finding the perfect case is not only about looking at what's out there, but also about showing how your facts are like this case and not like the more unfriendly cases. So when you're looking for a case, think about ice cream. Yeah, how is your case more similar to the one where you get ice cream and different from the times when you didn't? So here's an example of a case. It's about a non-compete issue, an issue where somebody leaves a dance studio, just as some folks are dancing there, and then goes to work for a different one. And as the judge says, there is so much authority. It is a deep and unsettled sea, and it will be a terrifying time to find them. Wow. Well, it's not going to be so terrifying. Let's take care of that for you. As I said, the goal is the perfect case, but you don't start with cases. That would take us forever, right? You've seen all those rows and rows of cases in the law library. Can you imagine just paging through them, hoping to find something useful? Well, that was pretty much the legal research process for a very long time, before awesome tools like Westlaw's AMJUR, ALR, state jurisprudence materials, and those things here at the basic level of the research pyramid. That's where we're going to start today, because secondary materials help you build that great foundation and then connect you to primary law in the form of controlling case law. So again, we will start with secondary sources. From the West search bar, you'll see what I've gone ahead and typed in, some words that are descriptive to my legal issue. Requirements of covenant not to compete, and then picked a jurisdiction. See, I may have even made a mistake here, because in a state law contractual issue, we're not talking about any issues of contract that are touched on by federal law, like maybe fair labor standards. We're talking about a state law covenant not to compete. This is going to be Ohio state law only. So go ahead and change that jurisdiction by giving that a quick click, and then creating your own search based on your legal issue, covenant not to compete. Maybe you might add in a few extra words that are specific to your fact situation, not maybe a dance studio, but something else. Or maybe you might even add some words about the parties, because as you'll learn, parties like minors, parties like people who, for other reasons, are not capable of entering into a legally binding contract, those folks are going to have different law governing them because of their factual situation. So as you create that perfect search in here, you will be thinking about the parties, you will be thinking about the facts, and you'll be thinking about the substantive rule of law. Let me just write that down. So parties, facts, and then rule of law. And if you don't know them perfectly, you will still get a pretty good search just by typing this: substantive law, requirements of covenants not to compete. When you do that, you will of course be greeted with a magnificent overview page. This overview page has a number of things along this left-hand side, but of course the one that we are looking for, secondary sources. My goodness, I'm a very poor artist. Excuse me, folks. Secondary sources right along here. And by giving that a quick click, you will find upwards of 3,000 secondary sources. Now, obviously, we don't have time for that either, so let's just see how we can winnow that down. Now, even though we will talk about ALR in just a second, I do want to start by talking about our second result. Take a look at that. Ohio jurisprudence is a jurisprudence. It's a desk book. It's like a lot of secondary sources, something that lawyers use to begin their research. Because why start it there? Because it connects you to other secondary sources, to the forms that you might use when you're drawing up a contract not to compete, and of course to the cases that we will use as the backbone of our memo assignment. If you didn't see this source right up front and center, you can filter. Let me show you how to do that. By clicking on this state button and using that plus drop-down menu there, you can magnify this level out and filter, just like you do when you are trying to find things to buy online, until you find the one you're looking for. Instead of filtering, of course, by shoe size or style, you will filter by jurisdiction until you get to the point where that perfect search, that perfect source comes up. Again, let's recap that the reason secondary sources are the best thing to start with are because these sources put a lot of resources at your fingertips. Things like the ALR or the key numbers or links to other forms, treatises, and practice aids. And of course, that they discuss the cases that you will use in your assignment. Now let's just say you're the author of one of these treatises and you're writing quite a bit about the legal issues raised by doctor non-competes. And from there, from these doctor non-compete issues, you're going to include a citation to some cases. You might say footnote 7 has more of them. And as you can see, scrolling down to the bottom here gives you those cases as well as some commentary that the authors chose not to talk about, the body of the article. But maybe this isn't what you want. Maybe you know that you're getting close, but you need to make sure that there isn't something even more relevant on point. Maybe there's a specific article of Ohio jurisprudence that says, hey, Ohio law is really specific as it pertains to truckers or dance instructors or something like that. How do we get there from this article? Because keep in mind, we just ran a basic search up here for an issue that's very complicated. That's where the table of contents comes in, right? Because the table of contents lets you browse it like a book, flipping through the pages until you get to the right page in the right section that is what we want. So give that table of contents button a quick. When you do that, you'll be looking just as what we have up here on the screen. Because what we've done is you can see here, you can browse it like a book at the very tall level of Ohio Jurisprudence Third, the whole desk book series. But then you see how thinly this issue is sliced. Contracts, legality of contracts, particular matters, contracts in restraint of trade or employment, particular contracts, employment contracts, covenants, not to compete. And you see here we're in the overview section, right? So this is going to give us an overview. Generally, okay, we need to have a non-compete that is reasonable. That word should probably be in my analysis. What constitutes being reasonable? Those look like factors, things that would make it more reasonable, less reasonable. And you can see how those cases might fit into that, as well as the requirement of consideration, which is a contract question as well, and then some factors to be determined, considered in determining reasonableness. Let's give that a quick click, because maybe those factors will be additional sources for cases. Go back to that ice cream question, right? A factor in determining reasonableness might be, well, you can decide. I apologize for leaving you hanging there on the previous screen cap. What I do want to show you here, though, is that if you click on factors to be considered in determining reasonableness, you'll see, again, generally an overview of some things, as well as specific things that may enter your analysis. Or if your analysis needs to be only on one part of the non-compete covenant, like let's say time and area, well, that looks a lot like geographic and time limitations. And again, when we do that, what do we get? We get the ALRs, of which we will talk about a lot later. We'll get the key numbers, which can help us find similar cases. We have links to treatises and practice aids. Ooh, trial strategy, one of my favorites. And then again, as we scroll through this article, links to cases that explain the points of law that the authors are making when they're saying, this is what reasonable geographic and time limitations look like. So let's recap. You start from the West search bar by typing in a search that's relevant to your legal issue, to your parties, and to your facts. Then you select the jurisdiction and then hit search. Once you're at those results page lists, click onto secondary sources and filter, filter, filter until you get to a desk book like a jurisprudence. In state law, Ohio jur, or AmJur for general U.S. common law principles, and then maybe even specific secondary sources if your issue becomes niche, like employment. Go back to that childhood dispute for a second, if we may, and when you think about the dispute, about whether somebody's entitled to candy after a doctor's appointment, there would be all sorts of factors that would be important. Maybe the type of doctor's appointment. Maybe it's a really, really important one, or a very big checkup. Maybe it's based on the child's behavior at the doctor's appointment. Maybe the child didn't throw a tantrum or a fit. Maybe the child was very courteous and polite to the doctor. Or maybe there are a bunch of other factors, like maybe the child's performance in school, the parent's overall mood. The West Attorney editors, when you're looking at a situation where there's a lot of case law, as in the case of the candy and the doctor's appointment, will have picked out all of the relevant factors that they see in a lot of cases. So by combining that huge body of cases and then parsing it out by legal issues, you will have the American law reports. And that's what we have right here. So just by typing it in across the top, ALR, or typing out American law reports, you will see that it populates down here. When you go sit over with your mouse, you will be able to give that a click and then search this source. Now, there are some things that we can do at this screen. You'll notice that there are categories that we could click into. And by clicking into them and clicking, we would eventually find ourselves at the right portion of the ALR. But rather than do that, what I've gone and done across the top is run a search, again, based on the legal principles, the facts, the parties, the factors, time and area restrictions, restrictive covenant. Maybe I've done some initial research in that Ohio juror, and I've found that's really where the fighting issue of the case is. Maybe time and area was either too much, or somebody is claiming that it's too much, but it really isn't. So go ahead and type that in, and then again, that search button or hit enter to search this source, American Law Reports, and see what we find. You'll see here this first result is incredibly meaningful for your analysis. It's talking about the enforceability of the restrictive covenant ancillary to employment contract as affected by territorial extent of restriction. So this is an area question. We might need to run more searches to find an ALR that talks about time. But you'll notice here when it was published, because back in 1955, the West editor said, let's bring in all the cases that have talked about this up to this point, and then since then, we've been adding, so that way, if you click into it and you scroll through the initial material, if you scroll through the article, you'll be eventually at section 8. You'll eventually be at section 8 where they talk about not just the rules which have come before, but the application of them to particular areas. So if we're really concerned that the other side is maybe claiming too big of a slice of the country to keep our client out, check that out. Area unlimited in scope. So there are even some times where a restraint of an unlimited scope was held reasonable. Wow, if we represent the employee, we need to be aware that those cases may be what our other side is going to be talking about, to maybe swing for the fences and say, look, if we can justify, if there's case law support for keeping somebody out of everywhere, then surely we can keep him out of, say, Toledo or Columbus. Maybe there are different things in the problem that we're looking at. Maybe part of a city, town, or village. Maybe an entire city and the vicinity. What does that word even mean? Vicinity in quotes. Hey, these cases are going to be relevant because they will interpret a particular clause, like maybe I'm going to keep you out of this county or these several counties. It just depends on what your particular fact situation is like, what particular problem it's like. Because once you know your problem, once you've read it carefully, once you read the facts, you can say, hey, this is an unlimited prohibition. I wonder if that's reasonable, and then focus in on those cases. Or it just says, hey, I'm going to keep you out of the state of Ohio, held unreasonable, and you'll focus on those. Do you see what's going on here? We're looking at the ALR, we're looking at these particular headings, and then we'll use those to be connected to relevant cases. Here is an example of what you would see inside the ALR, because once we've found those perfect cases, we're kind of picking out factors, but then we also need to know if any of them are going to click in Ohio. So what I've gone and done here is pull up an Ohio case, because once we are in a section, this is 125, and the reason I know that is because 126 is over here. But don't worry, you don't have to scroll through there. You just click on the blue to go to these sections. You'll see here, hey, nationwide covenant not to compete was reasonable. So that tells us something. Employer was a trucking company that focused on the expedited freight industry. Nationwide scope of the covenant not to compete was necessary in light of the fact that the trucking industry was a multi-state industry, and limiting the scope of the covenant to 50 miles from employer's headquarters did not sufficiently protect the legitimate business's interests of employer. Okay, so this is a pro-employer case, but it's very fact-specific. It's about trucking. Now, your problem might not be about trucking, but the more that you can tie it into the same idea, hey, this industry is a lot like trucking, the more justifiable the conclusion that a non-compete extends to the whole country. So that's the process by which we use secondary sources to get cases. And then, of course, we'll read the case with the West headnotes and everything by clicking on it. Sorry there. I was supposed to make a little brief announcement. More on that in a minute. But the process is going to be to start with secondary sources to connect us to cases. Here's what I wanted to talk about. Because at the end of each ALR annotation, in fact, at the end of each secondary source on Westlaw, you'll see something very important. It's called research references. And the research references are more links to helpful things, more relevant ALRs, as you can see here, that might be quite relevant. Because in this case, here we started with territorial extent of restriction, but there are also, hey, duration of restriction, time and area, right? Those two big kahuna factors, when we pick them out, you don't have to run a bunch of searches if you don't want to. You could, because you'd find it if you typed in time restriction, but you can also scroll to the end, which I highly encourage you to do, because when you do that, you will see not only those things, but also things like legal encyclopedias. This is the AmJur instead of the OhioJur. Trial strategy, which I absolutely love within proof of facts, forms, and so on. Even this rockstar Boolean search query, which the reference attorneys have created so that way you can punch that in and get awesome cases. So where is this? At the end of the ALR annotation. At the end of the secondary source, you will always see research references, and these are going to be invaluable to you. Now, I've shown you the best way to get to the ALR, but there are plenty of others. I'll show you another one very briefly, and that's the ALR index. Because as you can see, if you type in ALR index, you'll be able to go set over and give that a quick click. By typing in some, again, descriptive words that are relevant to your issue, you're going to be able to click into a curated list of ALRs that deal with that particular issue. So you'll see here we're kind of alphabetized as if you were scrolling through a book, but as you type in words and run some, you'll then be able to get some results, which will take you into those ALR annotations. But as I said, I believe the most efficient way is to just start by searching all the ALR or by starting at the state jurisprudence. So let's recap. What we did was we ran a descriptive word search, right? Non-compete, is it reasonable? And those take us to OhioJur, which is a state jurisprudence. And those state jurisprudences have links out to cases right? But more importantly, those Ohio juror articles are going to link us to ALR, right? And those ALRs are going to talk about things like time and area. And then at the end of the ALR, those research references are going to link us out to even other ALRs that talk about the factors that are going to be important in our analysis. There are research references over here too. So it doesn't really, well, it does matter, but no matter how you start your work, you can be linked out and connected through all of these resources. So again, we ran that search for enforceable non-compete. The Ohio juror gave us a background about it and said, hey, they have to be reasonable as to time and area, and then connected us to the ALRs that said, here's what reasonable time looks like. Here's what reasonable area looks like. And within area, we saw that there was an Ohio case about the trucking company. And then at the end, there were other ALRs about the other factors. So this is the basic level of the West Research Pyramid, right? This is the very bottom of it. So hopefully you're following along, you're excited, enthused about what we've found, because it's going to make the next two parts very straightforward. Start with the secondary sources, just as we've done right here. The next step is to use the key number system to find similar cases. I've told the story to you perhaps already. One of my favorite scenes in the Terminator movie is where Arnold says, "Hasta la vista, baby," and turns the evil Terminator into a million pieces of future metal. And those little pieces sit there for a second until one tiny piece touches another tiny piece, and they merge together and form a slightly bigger piece. And then so on until there aren't a million tiny pieces. There's just one big piece. And that's what we're doing here in legal research, right? You have started with your one idea, and you started putting it together with more and more resources. You've started by putting it together, by finding that Ohio juror that's on point, by gathering cases from ALR that can help you interpret the issue. Now we're going to use the key numbers to pull in even more similar cases. So here we've pulled up a case deal, just as if you were preparing for class. And what you'll notice along this left-hand side is something very interesting, right? You'll see the West headnotes, which you've used, as I said, to get ready for class. But to the right of it, you're going to notice something else. There's a key symbol, and there's numbers. I wonder if those are the key numbers. Interesting. So from these key numbers, you will be able to find similar cases, because we realize that you might want to find not just one case, but all the cases that talk about your legal issue. Not because your memo is going to cite to a billion cases, but because you need to be ready as a lawyer for your opponent's kind of silver bullet case. The opponent pulls out a trump card and says, this case is totally perfect. And what you need to do before that happens is to actually distinguish it yourself, right? To pick the strongest argument out of their bundle of sticks, snap it in two, right? And how do you find those cases? How do you find something that could be helpful? Yes, you start with secondary sources, but keep in mind that those secondary sources are national, right? We're looking at maybe the state of Ohio, just the state of Ohio. So what we are going to need to do is to find perfect case law in our jurisdiction. And the way we'll do that are those key numbers. Key numbers are after the research references, right? They're in the ALRs, they're in cases, they're in secondary sources. And as you can see here, they kind of get more precise as you go down. You start with contracts, okay, it's pretty general. And then you can see as we kind of dice it thinner and thinner, preventing disclosure of trade secrets. right? Let's pretend we represent the employee. The employer is going to say, oh, but we've got trade secrets. Pretty powerful trump card. How are we going to find cases that say, that's not a very big secret? Or, you don't have to worry about disclosure. How are we going to find those? All right. Now, one way we can do that is by accessing the key numbers system by typing in key numbers across the top and then clicking on the West key numbers system as it highlights over here. The other thing that we can do to access the key numbers is to click on that along the side, and then we'll do a little bit of browsing. No matter how you want to do that, come to the next page with me. These are West's key numbers, and you can see that, yes, we were looking at contracts, but there are over 400 topics of law that the attorney editors have been putting cases into for over a century. You'll notice what I've gone and done is to search for them relevant to my issue. I'm looking for an enforceable non-compete. I'm looking for just the basic understanding, and then the jurisdiction, Ohio State Fed. Of course, you can change that jurisdiction based on where you want to be. You can also click within here, within this body of topics, because there's going to be one that says contracts. And if you click on that and then keep clicking, you can find relevant key numbers. But the goal is to find one of these. So no matter how you do it, whether that's by browsing and clicking or by searching with that gray bar that we've typed into, no matter how you do that, check out what happens next. After typing in enforceable non-compete, you're going to see a bunch of different key numbers here within Ohio. And you'll see that most of them pertain to contracts, right? And that's kind of self-explanatory, right? We saw those key numbers within the cases, so you're going to see them here when you just run a search. But you're also going to see something here that says injunction, trade or business, non-competition, or solicitation issues. Now, you might wonder, what's an injunction? Go into Black's Law Dictionary and look it up, because it's going to tell you that that is a command from the court, right, that says non-competition and non-solicitation issues. What could the court be commanding you to do? Don't compete. Don't solicit your former clients. Those might be key numbers. Those might be cases where relevant issues might come up. If you click on any of these little dots, right, these little dots over here, you're going to be able to see something interesting. Because just like the key numbers within the case, the key numbers within this screen are broken out by level of detail, right? You could browse all of the contracts cases in Ohio. Probably not a good starting point, but you can see how thinly it is sliced. Restriction necessary for protection. Hey, that sounds a lot like, not trade secrets, because that's pretty specific, but hey, it's necessary for protection. Maybe there are other things, other business interests that might make protection necessary. So you could click into that. You could click into any of these blue linked key numbers to get there. What I've gotten done is click on the Westlaw homepage. That's the Westlaw logo in the upper left-hand corner to return to the homepage. And again, just type in requirements of covenant not to compete over here. I'm going to hit the search. And lo and behold, here we are. But you'll see here the key numbers are also accessible by just doing a general descriptive word search. This is the method that I prefer, because again, what does this let me do? This lets me go into secondary sources and find my Ohio juror. But if you prefer to start with the key numbers, we are easy like that. So you click on that or view all 10, not on secondary sources, but by clicking on key numbers or view all 10, you're going to see this. And what is that? That's the same, basically, set of results. Different because I ran a different set of words in the search, but the same idea here. Finding key numbers that will connect you to those relevant cases. And hey, what's this along the left-hand side? Secondary sources. There's an ALR. There's Ohio juror. See how all that's connected? without beating a dead horse, see how all that is connected, right? Because from the Ohio juror, this is the same thing that we were looking at about 10, 15 minutes ago. You get the ALR, you get the key numbers, and you click on those key numbers here to get cases in Ohio, right? Because if this was written all the way back in June 2016, chances are there may be new things out there. There might be new things out there. I mean, June wasn't that long ago, but there might be things out there that can help enrich your analysis, that can help you with crafting that argument. One thing you'll find when we train together, or if you just talk to me for any appreciable amount of time, is that I love to dance Lindy Hop. It's a 1920s American vernacular kind of jazz dance from the swing era. And this is an interesting dance case and a non-compete, because in this Arthur Murray case, what's going on is injunction. Okay. As we're reading this, you'll notice how this topic is connected to key numbers. Injunction. So the court might be commanding somebody to not compete. Why? Because of disclosure or use of trade secrets or confidential information. And we see here that the West Attorney Editor is summarizing this point of law. We can, of course, click on it, which is what I suggest that you do, to go to the opinion, so that way you can read the text of the court. But before you do that, have an idea of what's going to be talked about. The secret material that the employer is seeking to protect might just be just a general secret of the trade, rather than the employer's specific secret. Okay, well, how do we find more cases that talk about whether a secret is like double secret probation secret, to the point where it's my employer's secret, or if it's just a general secret? Because now, just like that one word that has a lot of different meaning on it, that's basically what we're called on to parse, is that idea of what is a secret. Well, let's take a look. Click on that key number, not injunction, of course, because we'll be here forever. But if you click on that narrowest level, you're going to see, ranked by topic, then date, a number of very interesting things, and quite a few interesting things. In fact, a little too many for my taste. And so part of that was my mistake. You noticed how I said, will probably just be an Ohio state law, because not a lot of federal law is implicated in an employment non-compete. So how do we change it? Go ahead and click. When we click change, instead of it saying include related federal, which it will say because that's how you start, just uncheck that, right? Just make sure Ohio is checked and then click apply. Now, even though this list of cases is pretty considerable with 99 results, I think that's probably not maybe exactly, but pretty close to what you might see when you're working on a big research project. Because if the answer was so simple that there was only one case out there, why, your work product would just be a citation to that one case, and then you'd be done. That we have so many results here is a challenge, but it's a challenge that we can meet by skimming these head notes, specifically trying to figure out whether this case is worth reading, whether it's worth incorporating into our analysis, or whether it maybe just discusses general principles of law or a fact situation that's maybe too different. So if I'm looking at, for instance, my job, which is not related to, milling machines and trade secrets that you learn there, that's interesting. So litigation support company, okay, I'm kind of in the legal field. Trade secrets agreement, so that might make it worth reading. Now what about this here? Former sales employees and certain trade secrets that you might have in connection with company practices. Okay, so presumably 2 and 3 might be more useful to read than 1, because 1 definitely looks more about manufacturing. So you see how this number can be winnowed down by skimming through the headnotes, and then through the headnotes picking out factors, picking out reasons why my situation is more like this favorable case and it's different than that unfavorable one. And how did we get here? Again, from these key numbers, which we can reach in a variety of ways. Let's recap. The West key number system is accessible from cases, right? Because at the top of your West search window, you'll be able to type in the citation for a case or find a case somehow, and you'll have a head note over here, which summarizes the holding, but then you'll have the key numbers. And those are broken down by different levels of detail, so that down here at the lowest level, you'll be able to bring out a number of manageable results. West's key numbers are also accessible from Ohio Jur and other secondary sources. Why? Because right at the top, it'll say key numbers. And then you'll click on those. But the reason that you click on these key numbers is to find relevant cases in your jurisdiction. And so that jurisdiction part is key because you may need to change your jurisdiction in order to adapt to the needs of your research. Again, the key numbers are all over the place, but where we learn to find them are from the cases or from Ohio Jur or from the West search window, just by running a standard descriptive language search, just by running non-compete and selecting Ohio. Because you'll see them along the left-hand side, key numbers. And then clicking on them in more detail, again, the goal is relevant cases in your jurisdiction. Now on to our final portion of using KeyCite to verify the law. You'll hear this phrased in a lot of different ways. Probably the most common one you'll hear is make sure your case is still good law. So let me show you an example, then show you how to find that information out for yourself in your own research. Here we are looking at a case called Lake Land Employment Group of Akron. And let's just start at the bottom and kind of scroll up. As a way of review, we see the West head notes. We see that this case talks about contract issues and whether there is consideration in a covenant not to compete, whether there are two mutual promises on either side to do something that they didn't have to do before, right? I didn't have to come give you a job, and you didn't have to agree not to compete. So is there that consideration in there? Okay, we've got the attorney-editor written summary. We've got the names of the case and the date. Okay, we're going. Oh, what's this here? That is a red flag, right? You can see the red flag right there just before it starts to say judgment reversed. So the red flag indicates some sort of severe negative treatment of this case. Severe negative treatment. How severe? Well, it's been reversed. And you know that a lower court, like the Court of Appeals of Ohio, which produced this case back in 2002, which decided it back in 2002, a lower court can be reversed by a higher court, like, oh, I don't know, the Ohio Supreme Court, which is what that citation there tells me. So when you're looking at a case, you will see in cases where there is KeyCite information, where this case has been cited by other cases, that red flag, if it has been overturned for at least one point of law in this opinion. Well, it looks like the West attorney editors have identified one big point of law, so it probably has to do with consideration. How do we find out for sure, right? How do we find out for sure? Let's take a look, but keep in mind, when you're doing research on a case and you see that red flag, that indicates that there is at least one point of law in here that is not good anymore. a little bit of a disclaimer, there is KeyCite information for a lot more than just cases on Westlaw. You'll see these red flags next to statutes, to regulations, to patents. A lot of things can be held to be invalid by a court. But for the purposes of this memo assignment, of this initial kind of rush of the first few weeks of law school, I am only going to talk about KeyCite information with cases. So you can see that this case has been reversed by another case, and we can, of course, click onto it. But what I'm going to do is ask you to click onto the red flag, whether that's the red flag over here or the red flag over here. You'll be connected to this page. This is the negative treatment tab. If you don't have any flags, if there are no flags, there's no yellow, there's no red, more about yellow in a minute. If there's neither of those, the negative treatment tab will be grayed out because there's no negative treatment on it at all. So we can see here, this document that we're looking at has been reversed by Lakeland. And you can tell that because it says most negative and it says judgment reversed. Okay, so this case that we're looking at, Lakeland in 2002, let me erase everything and start it over again. Lakeland in 2002 is this case right here. And it was reversed by Lakeland 2004 because it says so up here. So to understand what the actual rule of law was in this particular case, maybe they said, hey, here are the facts that are important. Here's the test that needs to be run. They got it wrong somehow. You will need to read this second case to get the final word of the court on it. Additionally, you will see negative citing references. So you will see how this key-cited document has been negatively referenced by the following events or decisions in other litigation or proceedings. So before Lakeland 2004 came out, there was another case that cited to it. You will see it is a federal case in the Southern District of Ohio. It came out in 2003, before 2004. And it talks about Head Note 2. Well, what is Head Note 2? Well, you'd know if you read the case, but if you ghost it over with your mouse, what you're going to see here is what it actually talks about. And this point of law that was made in Lakeland, the federal courts declined to follow it in Rash in 2003, and the Ohio Supremes overruled a portion of this case in 2004. So read Lakeland 04 to get the full picture, or ghost over the head notes to see what's discussed. The next thing I'm going to show you here is the history tab, because sometimes a case can go through a lot of different courts, right? We're just looking at something that came up, went to the Supremes, and then that was it. But what about if your case is a lot more complicated? How will you know which thing to read? How will you know what has the definitive statement? So what does this history tab do for us? Well, it gives us a graphical view of what's going on. Specifically, if you take a look here, the highlighting shows us that B is the case that we're reading right now, and that B is no longer good because of that red flag next to it. See, we're very careful about that red flag, red flag, red flag. Everybody gets a red flag. No. So here we're looking at B. B has a red flag next to it. B is in where? The intermediate court, right? Court of Appeals of Ohio. And what happened to it next? Well, A, B, C, D. Yeah, so then we go up to C. Here is the decision in the Supreme Court of Ohio that came down in 2004, which reversed the judgment of B, which is the case that we're reading, Lakeland 2002. And of course, where did that come from? Well, it doesn't start in the appeals courts, it starts in the trial court. So you can read the trial court order on Westlaw as well, and you can see that that is A, but that's no longer good either. Now, what does it mean if something is no longer good law? Let's go back to Lakeland.
Before we move on, I do want to explain that KeyCite pulls in more than just bad law. Bad. No, you'll also have a bunch of other things inside the citing references box. So let me just try and do a better job of drawing and explain you what that means. That means that this 2002 Lakeland Employment Group of Akron case is cited in two cases, right? It's cited and discussed by two cases. There are appellate court documents, so there may be briefs that talk about this Lakeland thing, and there are trial court documents too. Maybe somebody wrote a brief or a memo or something like that, then filed it with the court that talks about Lakeland. As we're doing all of this, keep in mind, let me recap the most important thing, right? Because when we see these red flags, that tells you that there's at least one point of law that's no longer good. What point of law is that? Read the other decision from the higher court, but also consult those headnotes, because when it summarizes that point of law, it could either be something that the reviewing court says, yeah, you got it right, or says, no, that's wrong. And again, you can ghost over the negative treatment tab in those headnotes along the side to see what's out there. A recap in the big, right? The goal of case law research is to show your judge over here that a higher judge from a more superior tribunal ruled in a court case with similar factors a favorable ruling using a favorable rule of law, but that this case needs to be good law. And by good law, that is a very simplistic way of talking about it, but again, what it is it is a case that hasn't been overruled for the reasons that we wanted. And the reasons that we want this case, again, are because the facts are really similar, the rule of law was good, and because of that, coming from a higher court, it applies to my judge over here, and that's why we like cases. That's why they can be very effective for us when we're doing our preparation for memos and other work product. So this red flag, when we see that, tells us the case has been overruled for at least one point of law for which it stands. And what point of law is that? Read the headnotes, then read the case. Check negative treatment tab and check history for more details. Especially if your case is very complicated and has a bunch of different kind of litigation pieces in its big old chain of being. You may see a couple other flags. One of them is the yellow flag. More about that stripe flag in a second. And that just says it's been questioned for at least one point of law. Does that mean that it's no longer good? Of course, you can still use it. But keep in mind that your adversary is probably going to latch on to that question thing as a way of creating arguments to counter your case. Before we move on, a couple bonus points for people who are really jazzed up about Westlaw. So the first bonus point opportunity comes from the table of authorities. That's this tab here from the cases. You can see all of the reasoning in Lakeland 04, because Lakeland is built on a bunch of other cases that it is citing. And those cited cases show up here in the table of authorities. As you'll learn in con law class, sometimes a loathsome rule of law, like school segregation, gets broken down piece by piece, attacked and chipped away at bit by bit. Well, you can see that there may be the startings of that here in Lakeland. A case may still technically be good law, but all the reasoning that it's based on could be full of holes. Figure that out with a table of authorities. This blue striped KeyCite flag lets you know that there is a pending appeal. And how do I know there's a pending appeal? Because when I'm looking up here, I see the blue stripe KeyCite flag, and it says there's an appeal pending at the Second Circuit. You won't see this in state law yet, but this blue stripe flag does show up in federal law. It's useful to know because even though this case may be the cornerstone of your argument, the Second Circuit could be revisiting it, i.e. turning it red sometime very soon. The last step of your research process is to use complementary resources. As I mentioned, the reference attorneys and on-demand webcasts are out there. You can also hit me up by email or tweet me your questions. I may make more of these videos if I see a lot of the same type of question from folks, just because that can be a really good way to answer a lot of questions at once. Let's talk a little bit about the process and that goal of rapid improvement. Yes, this has been an hour. Hopefully it hasn't been too laborious, but I did have to visit the West Research Pyramid because you have to start with secondary sources, because those are going to take you to cases, and then the key numbers are going to bring you on to similar cases, maybe in a lot of different jurisdictions that you happen to be researching in. Then when you're looking at those cases, use KeyCite to verify that that case is still good law for the point of law that you want, and then when you're done or through the research process, use those complementary resources. And I'm going to end the presentation on this slide because this is not the only legal research problem you're going to have. These aren't the only sources you're going to use. I mentioned KeyCite is out there for statutes, regulations, patents. Man, as you get out there and practice, there are so many complexities that are waiting to be learned. Use the reference attorneys for help right now. Check out some of those webcasts or drop me a line if you're looking for more specialized types of questions. Thanks for listening, and we'll talk with you soon.